Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. The first case on today's docket is in re amendments to Florida Family Law Rule of Procedure 12.510. So we have a certain lack of adversity of interest here this morning. Counsel, please proceed.
Thank you, Chief Justice Kennedy. May it please the court. My name is Corey Branfon. I have the privilege of appearing here this morning on behalf of the Family Law Rules Committee alongside my colleague, Ashley Taylor, the current chair of the committee. I am the committee's immediate past chair, its liaison to the Rules of General Practice and Judicial Administration Committee, and a member of its Summary Judgment Subcommittee, among others. Ms. Taylor and I will be dividing our presentation here this morning. I will be presenting the committee's majority position, and she will be presenting the committee's minority position with regards to Rule 12.510, governing summary judgment. By a vote of 17-4-2, the committee respectfully does not recommend the continued adoption of a modified version of Rule 56 within Rule 12.510. The committee's position is that the Rule 12.510 that previously existed, although imperfect, was not broken in family court and therefore does not require fixing. It facilitated the appropriate, limited use of summary judgment in family court. Even if intended as a clarification of the existing standard, the committee believes that this court's two opinions, its April 29th, 2021 opinion regarding Rule 1.510 and its July 8th, 2021 opinion regarding Rule 12.510, send the signal to the bench and the bar that summary judgment should be applied for and granted more expansively in family court.
Let me ask you this question, because I presided in the family division when I was a trial judge, and I presided over other divisions, all other divisions in circuit court, and it seemed like family was uniquely different, I guess, so to speak. The particular area that concerns me about this whole business of summary judgment is the area of child custody, where judges are required to evaluate and weigh the factors, statutory factors, in determining who gets custody of the children. And it concerns me that that is a very factually intensive area of matrimonial law, very emotionally charged. You don't see that in other divisions where both mom and dad are fighting over who gets to have primary custody of the children. And typically it's resolved in a trial because it's something that parties usually fight about. Here, under the new rule that the court has adopted, basically 20 days after the filing of documents, a person can walk in and just file a motion for summary judgment. And how in that particular area, specifically, put aside the division of matrimonial assets and liabilities, put aside all these other things, alimony, who gets the house, who gets the pot, who gets the pan. But looking strictly, what concerns me the most is the area of child custody, visitation, those type of things, where children, their future, their lives are at stake at this moment.
Thank you, Your Honor. I think that's an important question, and the committee certainly shares your concern. When Ms. Taylor gives her presentation, she will present the committee's proposal that time-sharing issues and parental responsibility issues be specifically carved out from the rule. Present precedential case law holds that parenting decisions should not be decided by default. And so certainly the committee would suggest that that be extended to what may be considered technical default, especially among self-represented litigants, for a failure to comply with the intricacies of the revised rule. Family court judges have an independent obligation to confirm that parenting plans and parenting decisions, time-sharing schedules are in the best interest of the child.
Doesn't that existence of an obligation solve the problem? I mean, isn't the fact that the judge can deny the motion for summary judgment somewhat missing from your analysis? I mean, if there's, let's say discovery hasn't closed, as we might expect, 20 days after the complaint has been filed. Discovery is still open. A party moves for summary judgment. Obviously, the correct legal answer, subject to reversal if the judge doesn't do it, is to say, there are issues of material fact. I'm not granting summary judgment. Discovery hasn't closed. Subject to your renewal of the motion at the conclusion of discovery, your motion is denied. Given the judge's obligation to do that right, why should we have the fear that you are discussing?
Thank you, Your Honor. Well, I think it's missing from that specific portion of my analysis, but not our broader analysis. We have concerns with increased applications generally, including in the context of parenting issues. As Justice Labarga pointed out, these are highly fact-intensive inquiries, not just in the area of parenting, but as I'll point out, as it relates to equitable distribution and alimony as well.
Your concern is with additional filings?
Well, yes. In my personal experience, and I think this anecdotally is reflective of the experience of many committee members, many of our family court judges are facing significant backlogs already. And since family court cases are resolved by bench trial and the judges are triers of fact, they obviously maintain very busy calendars, as do their brethren in civil courts, but they're also expected to find time to write judgments, lengthy judgments and orders. And
I guess I don't understand why the order has to be any longer than I just said. If the judge just says discovery has not yet closed, therefore there are genuine issues of material fact that may exist, motion denied.
In that specific instance, Your Honor, if it is as simple as discovery not being closed, I agree it would not require the same degree of time. However, if you are asking a trial judge to review voluminous summary judgment evidence and try to make those determinations in the context of parenting decisions, I think it would be a significantly more time-intensive inquiry. And if they're being denied, I don't believe it's a productive use of the trial court's time, where they could be hearing other motions regarding parenting and temporary relief motions, for instance.
But counsel, it sounds like when you're talking about all of this material and evidence and things they're looking at and weighing parenting, I mean, those are material facts in dispute. I mean, a glance at that would say this cannot be decided as a matter of law, denied. I mean, summary judgment has been around in family law, I mean, before now. It's very rarely used because it is so fact intensive. So how is this change going to cause that level of catastrophe for the family law?
So I think the signal has been sent to the bench and the bar that the court is interested in this being used more, not just in civil, but in family courts. Anecdotally, it's being something that's discussed among the bar. So again, I think you're going to see increased applications. And as I would get to later in my presentation, self-represented litigants are especially vulnerable to not responding properly. And this does give courts discretion to grant summary judgment for essentially technical failure to comply with the rule.
Wouldn't that be true under the current rule?
Yes, it would, Your Honor. But again,
I mean, it seems like the arguments that you're making are arguments against any summary judgment rule in the family law context.
And certainly I expected that question. So it is hardly used now. And so I keep going back to...
So why do you think it would be used? I mean, it's fear that it would be used in the future in cases that are not proper for summary judgment, right?
Well, I think whether it's proper for summary judgment on an individual basis is going to be a determination for the trial judge in that case.
But I mean, you can look at the universe of cases, and I could agree with you that most of the cases we're talking about, best interest of the child custody issues, I mean, all of those things are not going to be proper for summary judgment. So I don't know why you would anticipate that folks would be filing motions just because we have what I view as a more sensible standard.
And I certainly understand this court's position. My response to that would be, again, anecdotally, there is discussion among attorneys attempting to use these more. Obviously, the evidentiary burden for defeating them has been raised, I think, in this court's April 29th opinion, and I'm paraphrasing. It says that it'll no longer be sufficient to cite nearly any competent evidence to establish a dispute. And then, as I would get to later, the Commission on Access to Civil Justice study from March 2020 shows us that 60% of our cases involve a self-represented litigant. So you do have a substantial risk when they're being filed more of more technical failures.
Let me go back to the point that was raised earlier. Because what's going to happen is, as soon as the 20-day period expires, somebody's going to file a motion for custody. It's going to a motion for summary judgment on custody. That's just the way it is. the suggestion is, well, why don't you just deny it because there's more discovery to be done? But the problem is it defeats the whole purpose of why we, this court, amended the rules of procedure to bring it more in line with the federal. And there we said the Florida and federal rules of civil procedure share the same overarching purpose, quote, to secure the just, speedy, and inexpensive determination of every action. So if we're going to say too early for this motion, come back later, well, it's not going to be ripe, really, until the day before trial, so why have this order to begin with?
I agree with Your Honor. I do think in those many instances it could be counterproductive. And more to your point, I believe that, and the committee believes that the rationale underlying this court's April 29th opinion in the civil rules do not apply in equal force to family law. For instance, the benefit of avoiding impaneling a jury. In the context of family court cases, which are obviously resolved by bench trial, it's not a question of whether you get before a jury or not. It's a question of when you get before the judge and in what manner. Similarly, the decades of federal case law, Celotex and others that this court has cited, talk about essential elements. We don't have them in family court. And family court cases are governed by state law and statute. And so you're not going to have corresponding causes of action in federal courts and be able to analogize the material elements. So those are two things that were cited by this court as main reasons for its adoption for the standard in civil court. And of course, we infer the other main point is to just generally make it more available, make it used more commonly. And I have a few other important reasons why I think that it doesn't work in family law in the same way. And whether it's granted for technical failure of the many self-represented litigants to respond, or whether it's denied because discovery isn't closed or they're multifactorial decision-making processes, it's not productive. So
Counsel, is the committee more concerned? It doesn't sound like the committee is concerned about two self-represented litigants going against each other because arguably they're not going to use this.
Right.
And it doesn't sound like you're concerned about two attorneys. It sounds like what you're mostly concerned about is when one side is represented and one side is unrepresented.
That's correct, Your Honor. And so we understand, this is my 5th year on the committee, I understand as a practice we don't make textual distinctions in the rules between self-represented litigants and represented parties. You know, there is precedent at Supreme Court of the United States in Haynes v. Kerner, that's 404 U.S. 519, a 1972 case, distinguishing between self-represented litigants and represented parties in how you construe pleadings. And so the filings of self-represented litigants are held to a less stringent standard. And so if that's not faithfully executed in this state by our judges, there's a chance that...
Practically speaking, though, counsel, I mean, that seems to be how trial judges, I mean, in my practice, I practiced family law. I mean, trial judges are very careful in this state to ensure, especially when you have represented and unrepresented, to ensure that all parties are treated equally, that it's a fair and just process. So it sounds like you're concerned about the trial judge's application of this in an unfair manner. And is that something that the committee thinks is happening? Is it going to happen? I mean, I'm just trying to understand what the concern is.
You use the term unfair, and I think you touch on something important. Our courts are courts of equity. And I obviously can't, I agree that judges, by and large, try to dutifully and faithfully execute their duties and ensure that equity is done. Although summary judgment may be an integral part of the procedure in federal court, and now in this state, again, as this court cites in its April opinion, I wouldn't suggest that it is synonymous with the concept of equity. You are not necessarily getting your full day in court. Self-represented litigants especially are being held to to respond to an intricate rule under a burden far more than that imposed in connection with a default. To avoid a default, you get a summons. You have to respond. You have to admit or deny allegations in a numbered form. It's not that hard. To avoid this, you have to get the motion. You have to understand what's being served on you. You have to know there's a rule. You have to understand the rule. You have to be able to identify what a material fact is. You have to be able to identify the corresponding evidence. And now, most importantly, under this standard, you have to be able to contextualize it sufficiently for the court. And yes, I hope that every trial judge will dutifully analyze these situations and try to ensure, even under those circumstances, that equity is done. But do I have concerns, especially when they're facing, in many instances, months-long backlogs? This rule gives them significant discretion. And I think they'll do their best, but I think if summary disposition is used widely in family court, there is the risk that inadvertently the confidence in the judiciary will be eroded among self-represented litigants and the community at large who rely on their day in court and sometimes fumbling through the evidence to try to get their point across. So with that, I see that my time is up. I thank the court for its time, and I yield to Ms. Taylor. Thank you.
Thank you, Justice Kennedy, and may it please the court. My name is Ashley Taylor, and I am the current chair of the Rules Committee. I am here today to express the minority position of the Rules Committee. As Mr. Branfun expressed, that while the committee does not believe that the rule should stand, we do believe that if the rule stands, there should be certain amendments to the rule to
Well, that's
address.
not really a minority position, because you're still opposing the rule, correct? You're just saying, well, if the rule stays, you're going to, we'd prefer that you adopt these changes to it.
Yes, Your Honor.
I mean, the other part of the committee doesn't disagree with that, do they?
No, Your Honor. The committee feels that if...
It's an odd way to describe it as a minority position.
Yes, Your Honor. Understood. The committee feels that there are certain unique aspects of family law that should have the rule be tailored to these aspects. These are cases that involve, for example, people going through divorces or issues with their children. The committee recommends certain specific necessary changes throughout the rule. These modifications can be explained as resting on 4 unique aspects of family law. One, as we previously discussed, is children's issues. 2 is the fact that there's mandatory disclosure in family law cases. 3 is that there is a large number of pro se litigants in family law cases, which is around 60%. And 4 is the fact that family law is a court of equity. So the committee's first proposed change relates to children's issues. We believe that in cases involving children, there should be a carve out to the rule. And specifically, we are stating that we want a sentence, we are asking for a sentence that summary judgment may be sought to address the issue of paternity, but may not be sought to resolve the other issues relating to children, including time sharing and parental responsibility. The reason for this is that in making determinations relating to children's issues, the court must make a best interest determination. This determination requires considering certain factors that require testimony and evidence, and the committee feels that summary judgment is just not the proper tool to accomplish that. So we do ask for this
Never be the proper tool? It can never be the proper tool. That's the committee's position.
That is our position, Your Honor.
So let's imagine a parent who disappears, absconds.
Yes, Your Honor.
Let's say we're able to establish that other parent has left the United States, and all we know is that the parent is in some other jurisdiction, doesn't want to come back. There's no way that summary judgment could be appropriate to resolve that conflict. Help me understand why it can never be appropriate.
Your Honor, in that case, I believe the court still would have to make a best interest finding, and I believe the court needs to address the parent to find out the factors to meet that finding, and that would require a hearing to do so.
Perfect. So if the court must nonetheless make those factual findings, isn't it true that this sort of fear that's being expressed that there will be a ruling on summary judgment really vaporizes, because a motion, even under the facts I just gave you, would never lie, right? So the court will deny summary judgment. Help me understand what the problem is. It seems to me there's no skin off the court's nose to just say, okay, I read the rule, summary judgment's not appropriate. I don't need to be told that summary judgment's not appropriate. I can apply the standard, motion denied.
That's a good point, Your Honor, and the reason the committee is asking for this carve-out is to just prohibit having these motions filed. So if it's never going to be used, we think that putting in the text of the rule that it can't be used.
I guess that seems to me a very thin reed. I don't know, can you direct me to another time we've said that a rule should be changed to prevent the court from hearing argument from parties? I mean, as a general rule, we ascribe to parties a rationality in their self-interest, so we don't expect parties to be making motions that are against their interests and that will be deemed frivolous. nor do we ascribe to judges an irrationality or a laziness that they're going to just sort of do the wrong thing under the law. I guess that's the part that really sort of grates on me, is this idea that, you know, we're expecting our judges in the state of Florida to do something procedurally improper under your view of the world, which, by the way, we would have a chance to reverse, right?
Your Honor, I don't believe it's that we are concerned about the judges doing something improper. I think it's the fact that judges would have to deal with these motions at all. If the fact that it would never apply, if we carve it out from the rule, they don't even have to have it in front of them. They don't even have to spend the time dealing with it, because practitioners cannot file the motion to begin with if it's carved out from the rule. The other area that the committee would like to have a carve out is the fact that we have mandatory disclosure, which is very unique to family law. In family law courts, 45 days from service of the initial action, you must exchange for certain financial information. In the way that the rule is written currently, this motion may be brought 20 days from commencement of the action. So, for example, if a party files a motion for summary judgment, the responding party may see a material fact, but not
the 20-day period is in the existing rule. Prior to the adoption of the new rule. The previously existing rule.
It is, Your Honor. And to be candid, the committee...
So that wasn't a problem, was it?
The rule has been used very sparingly as it currently stands. So we've identified this rule during our analysis. And to be candid, if the old rule, if you will, stands, the committee does intend on going to address that issue, because we've identified this and we do think that this is an issue that does not match with our mandatory disclosure requirement. And so the committee is asking that we revise the rule to match with this requirement so that a motion for summary judgment not be filed until 45 days following the initial proceeding. The third area that we feel has requested changes relates to the large number of self-represented litigants in family law cases. Now, we have certain verbiage that we've put throughout the rule that we think makes the rule clearer for litigants, but one of the main proposals we have is under subsection A. Now, the committee under subsection A believes that it would be important to put a party on notice not just of their duty to respond to the motion, but the fact that they need to provide a factual position in that response. For example, we already have in a petition for relocation this kind of language where there is a similarly serious result if a party doesn't respond. So the committee believes that because of the finality of summary judgment in a family law context, this language creates an extra layer of protection to put parties on notice of what their duty is when this kind of motion is filed. And this ties into the recommended changes in subsections D, E, F, and G of the rule, that the committee feels that there should be a hearing when there is a motion for summary judgment that is to be decided. Now, having a motion for summary judgment decided runs the risk that's akin to a default judgment being entered. The difference with a default judgment is you have personal service. We don't have personal service with a summary judgment. So the committee feels that having a hearing gives the court the opportunity to have parties be heard on this issue so that their case is not adjudicated by a procedural failure to respond. And for the parties who do receive and review the motion, they potentially lose the opportunity to explain to the court through testimony their position. And as we've mentioned, these may be parties going through divorce. These may be parties determining issues with their children. We believe that the proper method to determine this is through testimony in front of the court in order for them to have that access to the court system. The final difference that is unique to family law is that it's a court of equity. We have under certain statutes, for example, Statute 6108, which is alimony, Statute 61075, which is equitable distribution, the court must consider any factor necessary to do justice and equity between the parties. In order to present any and all testimony to do justice and equity before the parties, we believe that the court should be hearing these parties so that they can hear the testimony, they can hear all the facts at issue, and in order to use their equitable powers, a hearing would accomplish that. So on behalf of the Family Law Rules Committee, I thank you for the opportunity to be heard today. If you have any questions, I'm glad to answer them. Also, if there's anything that Mr. Branfin or I stated today that you would like clarification on, we are more than happy to submit a written memorandum. Thank you.
The only question I have is, it seems like all of the changes that you're proposing are changes that if you'd thought about it, you would have proposed for the current summary judgment rule. Is that correct?
I think that's a fair statement, Your Honor.
Okay.
Yes.
All right, well, we thank you both for your arguments in this case today.